Hello students and welcome to the lecture. So students, as you can see that in this lecture we are going to start a very important topic, that is the National Commission to review the working of the Constitution. Okay. And basically in these all are the topics that we had scheduled for the discussion. Like first we will take the introduction of the commission. Then we will see the terms of reference of the commission. Then we will see 50 years of working of the commission. We will see the area of concerns, the Commission's perception. Thereafter, what are the recommendations of the Commission and earlier efforts to review the Constitution. Okay, so these are going to be the topic that we are going to cover within this lecture. Okay, and this lecture is going to be very important. Why? Because so far, whatever we had talked about, we have talked about the Constitution, right? Everything is related with the constitution, the political structure, how the things work in our country, that all the things that we have covered. And basically now we are going to cover the special commission. I would like to say national commission, but I would like to say the special commission that is constituently established to review the constitution. Like we had prepared a constitution on the you can say in the year of 1949. Okay, we implemented it in the year of 1950, and after implementing it, we had thought that basically, okay, we have invented the constitution and this the things are going on, but how we would know that whether the constitution and its principles are working as we require them or not. So basically, to this we had established the National Commission. Okay, and the National Commission is specifically tasked to review the working of the constitution, like how does the provisions of the constitution working and is it in the way we require or slight or more deviate from it. That is the main thing we are going to concern upon. Okay, so just let's have an introduction. First point. So the National Commission to review the working of the constitution, in the short form it is also known as NCRWC, okay, was set up by resolution of the Government of India in 2000. Almost after the span of 50 years, we had established that kind of commission. Okay. And the commission is a multi-member body. It is a 11-member commission. It means that not a single person within this commission, but there are total 11 members. And these members, for the first time when it was established, was headed by M.N. Venkatachelya. Okay. And he was the former Chief Justice of India. Okay. And basically, when the commission was set up in the year of 2000, under the leadership of M.N. Venkatachelya, it submitted its report in the year of 2002. It means that it take almost 2 years for reviewing the working of the commission, prepared the reports, and then submitted to the parliament or the government. Got it? So this is the introduction part. Please keep this thing in your mind. So after finishing the introduction, which is quite simple, now we are going to check out the terms of reference of the commission. Okay. So according to these terms of reference, the commission was required to examine. Like basically we are going to see, now we have found out this is the commission. Okay, we had found out this is the commission. Okay, what are the terms through which we could understand the reference to the commission? What are these terms? So basically, as per the terms of reference, okay, towards this commission, the commission was tasked to examine in the light of experience of past 50 years. Why? Because the constitution was implemented in the year of 2000 and the commission was, in the year of 1950. I'm very sorry for it. The constitution was implemented in the year of 1950 and basically the commission was set up in the year of 2000. It means the time period was 50 years. So whatsoever we had the experience in the last 50 years in reference with the year of 2000 as to how far the existing provisions of the constitution are capable of responding to the needs of efficient, smooth, and effective system of governance, as well as the socio-economic development of the modern India and recommended changes, if any. Like basically, we wanted to know that whatsoever the provisions we had provided in the Constitution in the year of 1950. However, we have amended the Constitution so far till the year of 2000. But these existing provisions, including the original provisions and the amending provisions, are these provisions capable enough to fulfill our needs to make the efficient, smooth, and effective system of governance, or are they capable enough to meet the demands of socio-economic development of the modern India and recommend changes, if any? So basically, we could conclude like our prime concern was that basically the provisions that we had established in the Constitution in the original form, these provisions are somehow governed by the existing conditions of that time. Like if we will talk about it in the year of 2024, when we compare it in the year of 1950, what do you think? Are the changes or other things are the same? No. The world is dynamic, so does the constitutional provisions are to be changed. And basically, we had amended the constitution several times. Got it? But still, after doing these things, we require to create a proper understanding of the system. Proper making of the system, like how does the amendments and the existing provisions, this combination is how much capable enough. Got it? And if we found after the report of the commission there are any recommended changes, then how do we make them? Got it? So the terms of reference clearly specified that the commission should recommend the changes that are required to be made in the constitution within the framework of parliamentary democracy and without interfering with the basic structure or the basic features of the constitution. Got it? So basically here we are seeing the basic structure or the basic feature, and we had already covered this. So let me just make it revision for you. Basically, when we established the constitution in the 1950, so the constitutional makers had a thought, had a perception that the things will be changed. Okay, the things we had in the 1950 are not the same things we have in the year of 2024. So basically, in order to provide the mechanism to make the changes as per the current demand, our constitutional makers provided a specific article that is known as the Article 368. Got it? Article 368 stands for the amendment of the constitution. It states that whenever there is a need, the parliament could amend the constitution. Okay, there was a thing. But what happened? After the independence, basically several amendments were made to the constitution. And in the Golaknath case, for the first time in the year of 1957, for the first time, the Supreme Court, which is guardian of the constitution, which having the power to protect the constitution and check the powers of the executive and the legislature in terms of the constitution, the Supreme Court stated that basically the government or the parliament could amend the constitution as per the Article 368. Okay, but the amendment should be done to protect the basic features and the basic structure. That was the first reference of the basic structure or the basic features. But after a few years, Keshavnanda Bharati case, 1973, for the first time, the Supreme Court proposed an idea of the basic structure. Like what happened? Supreme Court only had mention about the basic structure or the basic features. Like the amendment power of the parliament should not be interfere with the basic structure or the basic features of the constitution. These provisions should not be, you can say, affected or this. But the main problem was that there was a no clear definition of the basic structure or the basic features. So how can that could be justified that the following amendment that was made for the time and for the, you can say, need of the time in the constitution is according with the basic structure or the basic features. or how we can say that the basic structure or the basic feature was not get amended. That is preserved as it is. So it required the proper list, like what are the provisions of the basic structure or the basic features. Okay. So after the 1973 in the Keshavananda Bharti case, the Supreme Court had proposed a list of the basic structure or the basic features that could not be changed. All right. So basically, when the terms of reference proposed in relation with the National Commission to review the working of the Constitution, NCRWC, basically they had a clear specification that the Commission is empowered to recommend the changes that are required to be made in the Constitution as per the current need. But these changes could only be made if they are in accordance with the parliamentary democracy. It means that the government could alone not make the changes. It requires a basic formula that we practice for passing any legislation and making any amendment. Okay. And the amendment should not interfere with the basic structure or the basic feature of the Constitution. Okay. These things should not be amended. The Commission clarified that its task was to review the working of the Constitution, like how the Constitution provisions are performing, and not to rewrite it. It means that basically the existing provisions of the Constitution, these are to be examined by the National Commission, how they are working. But the National Commission for working to review the working of the Constitution is not allowed to rewrite the Constitution. It means that it was only recommendatory form and advisory in nature. Okay. Suppose there is any provision XYZ. So the Commission itself is not empowered to change the XYZ, but they could only recommend or advises the way that the things could be made in the XYZ provision. Got it? Now let's move forward. The recommendations was left to the Parliament to accept or reject. Okay. It means that the ultimate power to give effect to the recommendations that have been accepted through the National Commission to review the working of the Constitution, NCRWC. Okay. These could only be accepted or rejected by the Parliament itself. Okay. And the Commission itself have no agenda before it. On its own, it identified the 11 areas of study and proposed to examine them. Okay. So we can say when the Commission was established, the Commission itself searched and clarified the 11 areas which they wanted to be examined. Okay. And then they examined them. Got it? And those 11 areas, including the following. First, strengthening of the institution of the parliamentary democracy. Okay. And these institutions could be the legislature, the executive, and the judiciary. Okay. Like these are the three organs of the governance structure of any country, if it is a democratic country. Legislature, that is tasked to pass the rules and regulations and make the legislations. Executive, they are tasked to implement the rules and regulations and the legislature that have been passed. And the judiciary is tasked to review not only the implementation of the provisions, but also the powers of the executive. And in addition to this, the judiciary is also empowered to make the judicial review. Okay. Like whether the rules and regulations which have been passed by the legislature are accordance with the law as per the Constitution or not, or the action that has been taken by the executive to implement these provisions on ground, whether as per the Constitution or not. Got it? These are the things. All right. Also, not only the strengthening of these institutions was the main aim of the Commission. Okay. but they thought far from it. But also, the commission wanted to increase their accountability or their responsibility towards the people of India. Like whatsoever the legislature is doing, the legislature is responsible to the people of India. Whatever the executive is doing, executive is responsible to the people of India. Whatever the judiciary is doing, the judiciary is responsible to the people of India. Why? Because if you ever read the preamble of the constitution, that is also regarded as a summary of the constitution provisions, then what you have noticed there, it is always written down, we the people of India. Okay, so basically it is the main fact that the constitution derives its power from the people of India. So if the commission is taking the charge to review the constitution, basically the commission is reviewed it for the ultimate aim of the people of India, right? That is the main concern. So that's why the increasing accountability of these parliamentary institutions by strengthening them and also increasing their accountability. Thereafter, the administrative problems, the social economic cost of political instability, exploring the possibilities of stability within the discipline of parliamentary democracy. Okay, like whatsoever the problems the administrative institution faced when they try to administer the area or the people and all. Okay, if there is any political instability in the country, okay, then what the cause, the social order and the economy has to be beared. That is the thing. And how we could make the things stable and the powerful, but these things should not be crossing the discipline limit of the parliamentary democracy. It means whatsoever should be done within done in the parliamentary democracy. Got it? Electoral reforms and the standards in the political life. Okay. Thereafter, the pace of the socio-economic change and the development under the constitution. Like as I have told you many times, the things are always dynamic. The environment in which we are living, that is purely and dynamic. There is no staticness in this environment. Okay. So the socio-economic thing or the socio-economic aspects of the political environment and all of this country are changing rapidly at a constant speed. Okay. So how we could make the constitution capable enough to tackle with these things. Also, how we could promote the promotion and the developmental activities within the sphere of the constitution. Okay. And assurance of the social and economic rights to the people, judging them on the three questions: how fair, how fast, how equal. Okay, like the socio-economic rights which they have been granted, how fair those rights were. Okay, how fast, it means that in how much time they got their social economic rights, and how equally they have got it. After this, promoting the literacy, generating employment, ensuring social security, elevation of poverty. Okay, like we know, India, a very large segment of the population is illiterate. Okay, so how we could promoting the literacy, that is the main thing. Thereafter, India, we know, is the world's highest youth population country. So how this youth could get the employment. Okay, how does we could ensure the social security of the people in the terms of finance, in the terms of society, in the terms of political sphere, and how we could elevate the poor. Okay, because also the large section of the India is below the poverty line. So how these things could be done. Thereafter, union state relations, that are also known as center state relations. We know basically in India we practice the federal form of government, right? Where the power is not in the one hand, but the power is in the two hands, the central government and the state government. Okay, And the federal structure in India was basically first established by which particular act? Now, this is the question I'm going to ask you. Which particular act established the federal structure in India? To answer this question, I will give you the time period of 30 seconds. You are required to think and answer. And your time is going to be start now. Just think about it. Already, I have told you this question many times. So I'm expecting the right answer from all of you. Just think. 10 seconds have been passed. Last 20s are remaining. All right. Last 10 seconds. Okay, the time's up. So basically, the Government of India Act 1935 that was passed during the British era. Okay, that particular act established the federal form of government, which means the central government is empowered to administer the nation as a whole, whereas the state government is empowered to administer the respective state. Okay, so that was the thing. So basically, what are the relations of the center and the state government? These are very important. Why? Because the central government, which is in charge of the nation, and the state government, which is in charge of the particular state, these both must be worked in coordination. And many times we have seen the overlapping of powers. Why? Because you can say that the central government or the union government that is basically in charge of administering the whole nation. They could exercise their power even in the states, which often rejected by the states because the states claims that the administration and the governance of the particular state must be in hands of the particular state government. The center should not exercise the powers. Whereas the central government sometimes claims that basically they are in charge of the national governance and basically they want to maintain the uniformity in the political and the governance structure of the country. So that's why they are capable enough to administer the particular state if required. Okay. And that is one of the bone of contention between the overlapping of powers and the conflicts between the union and the states. And these are not so much beneficial for the overall governance of the nation as well as the people of the India. Why? Because the people of India at the same time belong to the India and also residing in the state. Okay. For example, we can take an example. Suppose if someone is living in the state of Uttar Pradesh. Okay. Uttar Pradesh is a part of India, so technically he is an Indian. Okay. So basically now we can understand the central government has made some provision or a law. Okay. So that particular law or the provision is applicable to that person who is living in the state of Uttar Pradesh. Okay. Then the state government has also proposed a law regarding the same thing. Okay. So if there is any conflict between the state and the union law, then what will happen? Who will be the ultimate sufferer? The ultimate sufferer would be that person who is living in the state of Uttar Pradesh. Why? Because he is an Indian by the constitutional sense and he is residing in the state of Uttar Pradesh. So he is also liable and also administrable by the government of Uttar Pradesh. Right? So that's why maintenance of the center-state relation and reducing the conflict between them is very important. Okay. So how we could straighten the provisions of the constitution relating with the union state relations that are also the you can say the subject of study for them. After this, decentralization and the devolution. It means empowerment and strengthening of the Panchayati Raj institutions. So basically what happened? Originally, the Constitution of India provided the two forms of the government, central and the state. But after the some period of time, basically we had found it out. If we really want to make the progress on the ground level, then we must establish the third form of the government, that is known as the Panchayati Raj or the local government. Alright. Why? Because that government is located on the ground, so they are well aware about the situations of the ground more than any other. Got it? That was the thing. Right? So basically, which particular act we use to establish the Panchayati Raj institution? Now this is another question. 30 seconds you have. Time starts now. Come on, we had already covered them, so there is nothing like a rocket science for you. You can easily answer this. Last 15 seconds are left for all of you. Just think fastly and think accurately. Time is going to be up. Okay, the time's up. The correct answer is 73rd Constitutional Amendment Act of 1992. That was the act through which we established the Panchayati Raj institution in the India as per the local government. Similarly, 74th Constitutional Amendment Act of 1992 we used to establish the municipal corporation or the municipality for the local urban government. Okay, and basically we done this thing for the decentralization. It means we want to form a government that could be on the ground and some powers could be granted to these form of government so that they could work effectively. Also for the devolution. So how we could empower that particular government more and how we could strengthen them. Okay. Thereafter, enlargement of the fundamental rights. We know the constitution has provided the fundamental rights. How these rights could be done? Okay, could be provided more and more to the people so that we could ensure the well-being of the people. Effectuation of the fundamental duties, like the basic duties that a person or the citizen is required towards his nation, how these could be effective. Effectuation of the directive principles and achievement. Okay, these directive principles are basically talk about the socio-economic development of the people, and these are also the preamble objectives of the constitution. How these could be done. Thereafter, legal control of the fiscal and monetary policies, public audit mechanism. And the last was administrative system and the standards in the public life. So these were the 11 areas picked up by the commission for the review and for the purpose of study. All right. So students, basically in this lecture, we have covered till here. In the next lecture, we will continue from here. Till then, just revise the facts and figures whatsoever we have discussed in this lecture. Be ready for the next lecture. With this note, let's end this lecture, and what we say thank you.